Good morning, everyone. We'll start. Hope you can hear me. Can someone please, Gavin, can you hear me properly?
Good morning, sir. Yeah, I can hear properly.
All right, thank you. I think we have to start a new lesson today. We finished banker customer relationship last week, right? Okay, we'll start the new topic today. So we are going to discuss today. The topic is topic that we are going to discuss is appropriation. So in the Sinhala word that we the Sinhala word will right. Okay. So we have to discuss this one. The first topic that we are going to discuss is appropriation. So the Sinhala word that we use here, it's called Visarjanaya. Visarjanaya, that is the Sinhala word. Appropriation is the English technical word that we use for this concept. So what is appropriation? If a customer maintains several accounts in the bank, so this you have to very carefully understand the principle behind this. Now, if one customer maintains several accounts in one bank, so the law principle is there is an agreement to keep those accounts separate. So that is the main thing that you have to remember. Under the banker-customer relationship, there is an implied contract between the banker and the customer. If a customer maintains more than one account in the same bank, the implied contract is banker has to keep those accounts separately. In other words, you can't just combine the accounts of a customer as you wish. Number two, unless there is no contradictory agreement to the bank as to keep them separate. The agreement to keep accounts separate may be abrogated by subsequent development. So what will happen? If due to some development, the banker can join the account, or banker can combine the account. Otherwise, the banker has to keep those accounts separately. What kind of situation a banker, or under what situation the banker can combine accounts? Examples I have given here. For example, insolvency or bankruptcy or winding up situation. If it is a company, the customer, if the customer is a company, if company is going for a winding up, in a situation like that, the banker can combine accounts or join the accounts of that company if they maintain several accounts, and you can recover whatever the dues due to the bank before the court appoint a liquidator. So for that purpose, because the situation changed, the bank can combine accounts of a customer if he is maintaining more than one account. Then what is appropriation? Customer has a right to specify how the money deposited to the account is or to be used. This is called the first right of appropriation. Normally, under the law, the principle is the first right of appropriation is with the customer. So basically, if customer maintain more than one account, and if he deposits money into his account, or if money comes to a account, he has the first right to decide how should that money to be used. For example, we say customer has a current account and customer has a savings account. Or we say customer has two current accounts. One account is overdrawn, the other one has a credit balance. Or then the money comes to the second account where the account is not overdrawn. So the question is whether the bank has the uh, right to appropriate the money deposited to the second account and use that money to recover the balance outstanding of the current other current account where there is a overdraft uh, balance. So the law principle is that the customer has the first right, so he can give instructions or specific instructions to the bank how to use the money that he deposited or how the money deposited to his account by someone else. So that is called the first right of appropriation. Then the second right, if the customer does not specify how the money to be used, then the bank has second right of appropriation. So then if customer if he doesn't give specific instruction how to use this money, then the bank has the second right of appropriation. So bank can decide how to use that money. So that is called second right of appropriation. The bank can decide what they will pay. Usually it is first come first basis. So this is normally when it comes to banking, this appropriation comes with the payment of checks. Now we say customer has an account and customer has two accounts. We say a savings account and a current account, and that he has deposited some money so he has two accounts. He has two accounts and he has deposited money in account number 2, but he has issued the check from the other account. There's no sufficient funds in the account to meet that check. So then customer can give instructions to the bank to combine those two accounts and pay the check. So that is his first right of appropriation. That is a specific instruction that he gives to the bank. If he doesn't give instructions to the bank, then the bank has a right to combine account or appropriate the funds and pay the check. So when you don't have a specific instruction from the customer, the bank can decide what check is to pay. Normally, it is the first come first basis, first come first serve basis. That means if you get two checks, you first pay the first check by appropriating the money in the accounts. So if there are sufficient funds, then you pay the second check. So, however, if there is no specific instruction, it is the bank's choice. The bank can decide what to pay, what not to pay. So that is the accepted law principle when it comes to the appropriation. So if you have any questions up to now, you can or need any clarification, you can ask.
Sorry for disturbing. Yeah, so just I want to know about that. The customer has given the instruction to maintain two accounts separately, but when the check comes to the account, so the particular account is not sufficient balance in order to pay the check. So does the bank has bank a right to the transfer other account funds to this account? I mean, to another check.
Okay. Now, as per your question, the customer has given specific instructions to keep those two accounts separately.
Separately, yes.
Yes. Okay. So then you have no right to combine the accounts. So that means when the check comes, unless the customer give another instructions to combine the accounts and pay, you can't pay. Right?
But
So
the
because,
funds is available other accounts, but the customer has clearly given the instruction to maintain these two accounts separately. But the
yes,
thing is, the one account is the lack of funds, and other accounts the particular amount is available, right?
yes,
When the check comes, but customer has given the instruction, so we have to return the check. That's mean.
yes, correct. You have to return the check because he has given a specific instructions. So that means he has exercised his first right of appropriation. So he has given instruction not to combine the account. So one account has a lack of funds, the other one has funds. So he has issued the check from the account where the money is not sufficient.
Yeah.
So, but he has given instruction not to combine the account. So you have to abide by the instructions of the customer and return the check. If customer clear?
Yeah. That's has bank
Yes.
the bank has right to lien the other account and pay this check.
So
If it is the
lien means,
customer is not given the, I mean, that is sometimes the later on customer just ask from the bank because now I am having other funds, I am having the sufficient funds other account, but first of all actually he has given to the maintain to the two accounts separately, but sometimes after that he asks because now I am having this much of funds in other account and why you return this check, something like that. So it has the bank has right to lien other account and pay this check.
actually the lien is a different principle, law principle. It is not applicable here. It's lien is we are discussing the lien later. It's not lien actually. It is appropriation or combination of account. So lien, we can't say that we can't put the other account. We can't say that we can put the other account under lien. Under lien means that it is the lien we use to recover something from the customer. Here, but the issue is the customer, when customer give instructions to keep the account separately, the banker's second right of appropriation won't exist because unless the customer give instructions to combine the accounts, or if you don't have any instruction from the customer, then bank can exercise the second right of appropriation. For example, we say, as you said, the customer has two accounts and he has not given any instructions to the bank to keep the account separately, right? So in a situation like that, the bank can exercise the second right of appropriation because the customer has not exercised his first right of appropriation. So in that case, the bank can combine the accounts and pay the check. But if customer has given instruction to keep those two accounts separately, and if you return the check correctly, so that is the correct way to do that, right? Otherwise you can't combine the accounts and pay. Then the customer can't blame the bank. If he blamed the bank, that you have a reason to say that you have given clear instruction to keep these accounts separately, so therefore we can't combine unless you give instruction clearly to appropriate the money in the second account and pay the check. So once customer give instructions to keep those two accounts separate, then we have to abide by his instructions and we have to return the check. I know that customers, when you return the check, they comes and blame you, why don't you pay the check and I have money in the other account. But then you can explain to him, so that you have to say that the customer gave instructions to keep two accounts separately. So unless you give specific instructions to combine and pay, we are not legally, we have no right to legally to combine the accounts. Clear?
Yes, just another question. At that point, when the check comes to the bank to pay, so sometimes we contact the customer. There's a check has come to pay. Then sometimes he said, okay, then please use other account and pay this check. So if I mean that is we need to have a written or the email confirmation to pay this check, or orally we can give the confirmation.
Yeah, very good question. Yes, a customer can give instructions to the bank orally, that we have discussed before also. You can accept the customer's oral instructions. But safe side, I said in the previous occasion, and I quoted a case also, it is better to get that instruction in writing. So nowadays, of course, we have call recording facilities also, which we can use as evidence in court. So therefore, if you can record the instructions of the customer, verbal instruction, that is sufficient. Otherwise, what you have to do is you can say the customer that we will take your instruction, verbal instruction, but you have to send us a email, or we have to give us a letter. Then based on that instruction, that we can combine the accounts or appropriate the money in the other account and pay the check. So customer can give change his instruction. Previously, he gave instructions to keep the account separately. Later on, by his second instruction, that he can withdraw the previous instruction and give a new instruction to the bank to combine and pay. So yes, verbally he can give instruction. Bank has to accept verbal instruction. For the safety of the bank, we have to take that instruction in writing. So that is the answer for the question. Clear?
Yes, thank you, thank you.
Right. Then any other questions?
Excuse me. Hello. Hello.
Yes. Go ahead.
Just to add on something to that question,
Yes.
say in a situation where the customer has not given a written instruction to appropriate, not written instruction to combine the accounts. Say if what in normal scenario, practical scenario, what happens is when a check comes on a current account and the sufficient funds are not available, we used to pay the check based on the funds available in another account. So in that sense, if we pay that check, customer cannot blame us later on, no, because he haven't given any instructions to combine, not to combine accounts.
Yeah.
If he's
Yes, correct.
silent on that matter.
Yes, as I told you before, that now as per this principle of appropriation, you must understand the principle is this: the customer has the first right to appropriate. That means that he can decide how should his money in the accounts to be used. So that for that purpose, he has to give instructions to the bank. So if he has not given instruction, that means that he has given the opportunity to the bank to decide that. So then in that case, the second right of appropriation of the bank comes to picture. So that means if customer has not given any instruction, the bank has a right to appropriate the money of the customer's account as you wish. So normally what happens when we say, even though we say that the bank can decide how that you should appropriate the money of the customer's account as you wish, there are cases that decided say that the bank has a duty to appropriate the money in the customer's account for the benefit of the customer, not otherwise. So basically that is one of the thing that we have to be very careful. However, as you said, yes, if there are no instructions from the customer to appropriate the money or combine the accounts, or no instruction in that case with regard to the two accounts, then the bank has a right, that is called second right of appropriation, to appropriate the money in the account of the customer and pay. When you say that you have a discretion, remember again, this is a second right of appropriation, is a discretion. It's not a duty. the bank, it is not a banker's duty. So banker can decide. Now, for example, if you have two accounts, if customer has two accounts and he has issued a check from one account where no sufficient funds and the other account has money, so it is not a duty to the duty of the bank to combine the accounts and pay. It is a discretion, because a customer's duty is to issue checks or issue checks from the account that sufficient funds available. So that is his duty. But when you have a discretion, the customer can't blame the bank and say that you have not combined the accounts and pay. That is a discretion of the bank. So you can say that we have a discretion unless you provide money in the account or unless you give specific instructions to combine the account, we are not obliged or we are not duty bound to combine the accounts and pay. So the question, the answer for your question, if there is no instructions to combine or appropriate the money in the accounts of a customer, the banker has a right to appropriate the money of the customer as the bank decide and pay. So is that clear?
Yes, thank you.
Right. So any other questions from here? Otherwise, I will go to the next one. If there is an OD balance and no specific instructions, what is the situation? So one account, he has OD balance and no specific instruction from the customer. That means that he has not given instructions to the bank to keep the account separate. There are two accounts, right? Then the bank can reduce the OD by set off the deposit money. So what will happen if there is a OD balance in an account and if money deposited to that account, so the bank has a right to reduce the OD balance by recovering that money or setting off that money against the OD balance, unless customer has given specific instruction. That you may remember that we discussed a case before. The customer, it's an Australian case. You may remember that the customer has OD balance in his account and he deposited money to the account and he gave instructions to the teller to appropriate that money to pay the check, pay a check that he has been issued. However, the bank didn't observe or bank didn't follow the instruction. They recovered the OD balance. So then court held that the bank cannot do that. Bank has no right to do that when there is a specific instruction. But in a situation like this, if there is no specific instruction, but his account is overdrawn, then the money deposited to the account, the bank can utilize that money, appropriate the money and recover the OD balance. If there is a loan arrears, the bank can recover that from the customer's account if there is no specific instruction. Now, for example, we say the customer has taken a loan. His loan is in arrears. He has a savings account, right? The customer deposit money to the savings account, but he's not paying the loan account. He has not given specific instructions with regard to the money that he deposited to the savings account or the current account. So in a situation like that, the bank has a right to recover the loan arrears from the money deposited. If you have instructions, then remember that you can't do that. You can't take money from the accounts of other accounts to recover the loans. But today's situation, in our loan agreements and other general terms and conditions, we have put a clause in those agreements to say the bank has a right to combine accounts and recover any arrears of loans and ODs of the customer. So he has signed the agreement. They signed agreement. They don't know this about this clause. They don't read normally. The customers, they don't read. But if you read those agreements, there is a clause like that. So once you give that authority or give that consent to the bank by in writing, using those agreements, loan agreements and OD agreements or general business terms and conditions of the bank get that right to appropriate the accounts, combine the accounts and appropriate money. So that's how it operates now. When the money is paid and received by the bank with specific instruction, the bank must follow that instructions. That is the other important thing. When you received instructions from the customer, then you can't exercise your second right of appropriation. So the bank has to follow instruction. There is a case here, the Commercial Bank Company versus Sydney Limited versus Jalsad Private Limited. The customer instructions to the bank as how to credit should be appropriated must be a clear and unambiguous. So it was decided when a customer give instructions to the bank, how should his money should be appropriated, then that instructions, the customer has to give instructions, a clear instruction and also unambiguous instructions. So if the instruction is not clear, or if it is ambiguous, then the bank can avoid the instructions and appropriate the money as bank wish. So that is a case decided with regard to the instructions of a customer regarding appropriation of money in the accounts. The bank will not liable if they are not. So what will happen if bank has not followed the instruction, and if the instructions are not clear and if it is ambiguous, then if bank didn't follow the instruction, the bank is not liable. So otherwise the bank is liable and the bank has to return that money to the account if you have not followed instructions. So that is about OD balance and when there's no specific instructions. Any questions from here?
Excuse me.
Yes.
Suppose a customer signs the normal bank general terms and conditions documents, and subsequently, if he submits a request letter, will that supersede the original GT? I mean the general terms and conditions.
Very good question, right? Now it's like this. Now, customer initially give instructions or without knowing that he signed the terms and conditions, and which says the bank has the right to combine accounts, and subsequently he give instructions not to combine those accounts. So what will happen? Which one will supersede? It's like this. If customer give instruction not to combine accounts, if it is a general instructions, right? So that will not supersede the previous agreement between the bank and the customer, unless and until the amount due from the loan or the overdraft is settled. Once the OD or the loan is paid, then what will happen? That agreement, previous agreement, loan agreement or the OD agreement will come to end. So then customer instruction get the priority. However, for a specific instance or specific deposit, that he can give a specific instruction. For example, we say the customer has an overdraft facility in his OD balance in his account, and there is the savings account. So he has signed an overdraft agreement, and this overdraft agreement, there is a clause to say the bank can combine any accounts of the customer and and appropriate the money of the customer's any account. So later on, the customer, while the OD balance is there, he deposit money into his savings account with specific instruction. So he said, "This I deposit this 100,000 rupees to pay the salaries of my employees. So therefore, don't deduct this money for the OD." So that is a specific instruction given with regard to a specific deposit. So it's a one-time instruction. So in a situation like that, the most prudent thing is not to combine accounts or not to set off, because it is not clear then, because the principle is, if it is a general instruction, when there is a contradictory agreement, the general instruction will not get priority. Now, for example, if you go to this one, right, it says the principle, there is an agreement to keep accounts separate unless there is no contradictory agreement. So this is the qualification part, this one, right? The bank has an agreement with the customer, keep the account separate unless there is no contradictory agreement. So what is the contradictory agreement? Once you sign the loan agreement or overdraft agreement, that agreement says the bank has right to combine accounts. So then you don't, this agreement or the agreement to keep accounts separate comes to it. So the bank can at any time combine the accounts. So what will happen if the loan is settled or if the overdraft is settled? Then this contradictory agreement comes to end. So the overdraft agreement or the loan agreement comes to an end. Once it is over, the agreement comes to end, then the principle comes to a picture. So the principle is keep the account separate unless customer give instructions. So that is the principle. However, with regard to deposit money in the account, if we give specific instruction for that particular deposit or that particular money, it is prudent not to combine or not to appropriate that money to recover the loan, because it is then can be tested only in court of law, where that the principle of appropriation is subject to a lot of limitations that we are going to discuss later, where the principle is when there's a specific instruction for a specific transaction, that will supersede the general terms and conditions. So that is the answer for that. Is that clear, or you know?
Okay, thank you.
Any other questions? Okay, then we'll go to the next one. Right of third-party appropriation. So this is another area that we have to discuss. We have to think about. What about the third-party accounts appropriation? I have given here a case, WP Greenlaw and Company versus Union Bank of Manchester, decided in 1924. The third party succeed in action against the bank. The claimant sold goods to W and Sons on credit, and W and Sons resold the same to another party on a bill of exchange for the price. Then the W and Sons remitted the bill to the bank, and the bank credited that proceeds to the bill to W and Sons account and set off against the OD. So what happened? So this company sold some money, sold some goods to another party, third party, on credit, and the W and Sons remitted the bill to the banks, and the bank credited those proceeds to the bill to the W and Sons account, and after that set off the OD. The claimant claimed that the bill had been appropriated to their contract, which with W and Sons. Now, bill means bills of exchange. It's a separate contract. So a separate contract between the W and Sons and the other company. The claimant, that is the WP Greenlaw Company, sold some goods to W and Sons Limited, right? And they issued the bills of exchange. So what the bank did, the bank credited the money to the W and Sons account, and there's a balance in the OD, so they set off. The Greenlaw Company claimed that the bill had been appropriated to their account with W and Sons. It was argued that the notice of appropriation was given to the bank, and it was held that if the purpose was to arrange for the payments to the party and that person comes to know of appropriation of funds, he is entitled to claim the amount appropriated. So he said, the court decided, when there is a when there is an agreement between the other two parties with regard to the payments and the money deposited to the account of the customer's account, it is a notice of appropriation. So therefore, the bank has no right to. It's considered basically as a instruction or specific instruction. Here, in this case, the company has not given any instructions with regard to the appropriation of money. With regard to the appropriation of money comes to his account. However, this transaction is based on a bill of exchange. So once when the money comes to the account, the bank knew that the deposit or the money came to the claimant's account as a result of a payment of bill of exchange. So that means that money comes to the account of the customer for a specific purpose. So the notice of bill is considered as a notice of appropriation to the bank, even though the customer has not given specific instructions. So therefore, it was decided, if the purpose was arranged for the payments of a party and that the person comes to know of the appropriation of the fund, he is entitled to claim the amount. So it was decided, when the purpose of the money deposited in the account is informed to the bank, directly or indirectly, that is a notice or that is a instructions to the bank. So therefore, it is not correct if bank combine or set off the account. So it is, you see now, the appropriation is not that easy, or that it's not very direct principle that you can easily apply, right? Even for example, in this case, the customer has not given any written instruction or verbal instructions to keep those accounts separately, or he has not given any instructions to the bank not to appropriate the money which comes to his account. However, based on the transaction, it is very clear that the money that comes to his account to pay the bill. So in a situation like that, the knowledge of the banker about the transaction has been accepted or has been recognized as a specific instruction of the customer to keep that money separately without appropriating. So the bank appropriated the money or set off the money against the OD. It was decided it is a wrong act because the bank knew the transaction, and it was a notice, or it was a instructions of the bank. So therefore, the bank has no right to combine or set off the account. So the legal principle derived, if the bank knows the given sum or item has to be appropriated for a specific purpose, the right to set off cannot be exercised. Now, what you have to learn from this case, the principle is, if the bank knows that the given sum or the item has to be appropriated for a specific purpose, the right of set off cannot be exercised. So it is, now you see, it is not necessary the customer to give instructions in writing or verbally. If you have the knowledge that the money deposited to the account by the customer or third party to the customer's account is for a specific purpose, then your right to set off comes to end. So sometimes you know that customers, they have overdrawn their accounts, they have not paid their loans, but they deposit money for a purpose. That purpose, if you know the purpose, if it is conveyed, if the customer has conveyed the message to the bank, or if you know the purpose, for example, by the transaction, right? We say that there is a shipment is coming, so he deposit, or there is a bank guarantee to be claimed. So customer deposit money to meet that bank guarantee. So you have that knowledge. So because of this reason only that he has deposited. Otherwise, he has, even though he has not paid the, so he has not deposited this money to pay the loan or OD. So in a situation like that, if you use that money and if you set off the OD or the loan, and if you don't pay the bank guarantee, then the customer can sue the bank, because since the bank knows the purpose, you cannot use the right to set off. So that is, you see now by this the case, the law has developed from the principle. It is now not the notice. Even with knowledge is there, the bank has the knowledge of the deposit, knowledge the purpose of the deposit, or the money, the items comes to the account, then the bank cannot appropriate that money against the instructions of the customer. So any questions from here?
Yes, sir. Just I want to find out whether the account has been classified as NPA when what we discussed about the remittance came. So what will happen? I mean, that is, the account has been classified as NPA. So all the facility, I mean, that is, accounts has been
NPL means non-performing
non-performing facilities.
Non-performing category. So
Yeah,
the customer's account has been classified as NPL. So what is your question? Whether we can then, in that case, whether we
are we
can
allowed to set off these funds? I mean, that is the specific funds for the specific reason. What to say that, like to pay the bank guarantee or something like that. The customer has given the instruction, these funds to be used for this purpose. But the thing is, all other facilities under his name has been
Yes.
classified as a non-NPA. So what will happen? Yes.
Right. Again, a good question. So categorizing customers' account to NPL or hardcore or the bank, those are internal things of the bank, right? So NPL is not a legal principle. It is for the purpose of accounting and banking purposes to be categorized customers' accounts, right? We say good accounts, and we say delinquent accounts, and likewise we have different names. NPL is one of the name that we use in our practices or bank procedures to categorize customers' account to identify the customer's status. So it doesn't give any right to the bank to supersede the rights of the customer and the bank of regarding the appropriation. So even though the customer's account is categorized to NPL, if customer has given specific instructions with regard to his accounts in the money in the accounts, or if you know the purpose of the deposit of the money as decided in this case, the bank has no right to set off, unless, always remember, unless there is a contradictory agreement. Unless you have an agreement between the customer that you can appropriate any account or appropriate any money in his account to recover the loans. But remember again, as I told you before, if it is a general condition, it can be superseded by a specific instruction for a specific transaction. So therefore, even it is if the customer is categorized as NPL, the bank has no right to set off the money if the customer gives specific instruction, or if bank has the knowledge of specific instructions. Is that clear?
Just I want to another question. Actually, that's how we should clarify. That is what is the importance of this transaction? Just the customer can give this money should be transferred to some other account in order to meet their payments or something like that. So how we should clarify it is that such a important what is the measure that we use for the we have to utilize these funds for the purpose of bank guarantee or something like that is the value of the purpose. So sometimes how we should measure the transactions, I mean the instruction by customers in order to meet this requirement.
Yeah, basically, I think your question is whether the customer is genuine. Customer gives
Genuine or not, yes.
genuine purpose instruction, or whether he is giving a bogus instructions to avoid the bank's right to combine accounts. So it's like this. Now, we say customers give instructions to the bank not to combine, not to appropriate the money, and he deposit the money. He says that money is deposited for the purpose of meeting a check, right? So what you can do, you can hold that money. So when the check comes, that you can pay that check. If customers say this money is to pay my employee's salary, and therefore don't appropriate against the OD, so then you can't basically you can't investigate and see whether that customer is genuine or not. So then actually you don't have a right to combine accounts or set off the account. But remember, you will lose your right to combine, or you lose the right to set off. That doesn't mean that you will lose the right to recover the money of the customer. There are other avenues that you can recover without setting off or without appropriating the money in the account. So what you can do, you can take a legal path. You can file legal action against the customer and recover the money. So he is obliged to pay the money that he took from the bank. So it is a cumbersome, lengthy process, correct? The legal method. But it is good if you can set off the money and recover from his account. But when there is no right to do that, if you do that, that means that you will breach the contract and you have to pay damages also. That is one thing that you have to be very careful when you are appropriating money or when you are setting off money of the customer. So it is a right, true, but you have to exercise that right very carefully. So the answer is some instructions that you can observe the genuineness, but some instructions you can't observe, or you can't determine, or you can't find the genuineness of the instruction. However, in a situation like that, we have to accept the customer's instruction, whether it's genuine or not. Our right to set off will comes to end once we get instructions of the customer. Is that clear?
Yes, thank you.
Right. Okay, so then we'll go to the next one. Appropriation is irrevocable. It's another important thing that you have to remember. This is a one-way traffic. Once you appropriate the money, you can't reverse it. Now, for example, we say now customer has two accounts, or customer has two accounts, and he has issued a check, and you combine the accounts and you appropriate the money in the accounts and you pay the check. So later on, the customer dispute the transaction. Customer say, why did you do that? I didn't mean to pay the check. So why did you do that? So can you reverse the check? Reverse the transaction, a combination of account or appropriation of money. So the legal principle or the legal status is, once it is appropriated, the bank cannot reverse it. So once the bank has made the specific appropriation, the bank cannot alter it subsequently. Appropriation is final and conclusive. So if it is a correct appropriation, good. If it is a wrong appropriation, then the bank has to bear the damage, or bank has to pay the customer's damage and bear the loss. So it is very important. That is why we say it is very, very important, and also we have to act very cautiously. Otherwise, once you appropriate the money, it's not possible to reverse it. So delay versus Lloyd Banks case in 1972, it was decided once appropriated cannot seek to vary that appropriation afterward. So it is decided either customer give instructions to appropriate, or if bank takes the call and appropriate the money, the bank or the customer both cannot reverse or vary the transaction or vary the appropriation afterwards. So that was decided in this case also. That is the principle. Then limitations laws for appropriation. This is very important point that you have to remember. As I told you before, the appropriation right is there, but it is subject to many limitations. So it's basically, if you read this, if you understand these the limitations, that you will understand, or you will see that even though the right is there to appropriate the accounts, basically practically it is not possible to appropriate. It is very hard to do an appropriation because there are so many limitations. So the first one is the appropriation, the limitations with regard to the prescriptions. Prescription means that, you remember, they are under the law to take any legal action or to take any recovery action. There is a prescribed period. If the prescribed period is expired, then the bank cannot recover that money. So that means that you have to forget about that, and that you have to basically you have to forget about, you can't recover. So you have, that is a loss to the bank. So that's why we say the bank officers to take appropriate action within the prescribed period. So that we are going to discuss later with under the recoveries. However, remember, there is the ordinance or the act called prescription ordinance. As per the prescription ordinance, when there is a written promise or the contract or undertaking in writing, the prescription period is 6 years from the default. Now, for example, we say a situation like this: the customer has a overdraft facility. So there is an overdraft agreement, written overdraft agreement. The customer enjoyed the overdraft and he defaulted at a point. So he defaulted, we say in 2010 he defaulted. So after that he has not paid any money. So the bank has not taken any action. Now interest accumulate and the account goes on with the overdraft balance. All of suddenly customer deposit money to his savings account in 2021 after 11 years, right? After 11 years that he deposited money to his savings account without no instructions to the bank. So there's no specific instruction, though he deposited money. Now the question is whether the bank has a right to combine or right to set off or appropriate the money in the account of the savings account to recover the overdraft outstanding. Now you see there is a agreement. So agreement defaulted in 2000, year 2000, we said 2010, right? Now we are in 2021, 11 years gone. Prescription period is over, 6 years gone. The bank's right to recover has come to end. So therefore, if you combine account or if you set off the money deposited to the customer's account, the customer can challenge that in court of law, and then the bank has to, if court decide that it is prescribed, obviously that on the face of the transaction we can see it is prescribed. So then the bank has to return the money. Not only that, if there is any damage, the bank has to pay damages also. So that is about when there is a written promise or written contract. When there is no written contract, without any security or any written promise or any written contract, what is the prescription period? Prescription period is 3 years from the date of default. From the date of default. Remember, it is not the date of the agreement, from the date of default. From the date of default, if you have waited more than 3 years, that means the right to recover is expired. For example, overdraft facility, casual overdraft facility, we say without any security, without any agreement. So we pay customers checks by overdrawing the account. We say we paid a check for 500,000 because he was a good customer at that time. So he used to take overdraft. So the bank manager decided to pay a check without any security, without any written agreement. So it is a casual overdraft given to the customer without any written agreement or promise. Now he has defaulted. We say now he paid. We paid the check in 2015. Now we are in 2022. The prescription period is gone as per the prescription ordinance. So as you are aware, when overdraft, when it is an overdraft, customer has to pay when the bank immediately that he has to pay the overdraft balance. So he has now given OD the account, overdrawn the account in 2015, and he has defaulted in 2015, and time has gone over 3 years. Time is prescribed. Now this year he deposit money to his savings account or another account. So the question is whether we can recover that money. Answer is very clear. Since it is prescribed, the bank cannot exercise right to combine or right to set off or appropriate the money to recover that money of the overdraft account. So any questions from this one? Any clarification is needed, you can ask.
If it is litigation is processing, what will happen after 3 years? I mean, that is this scenario. Litigation is processing.
Can you repeat the question? If litigation is
Processing from the bank end. So
right. So okay, good questions. If you have taken any action within the prescription period, any action means any legal action within the prescription period, then the prescription comes, the counting of prescription comes to end. For example, if it is a loan facility or the overdraft facility given on a promise, a written promise or contract, if you have filed a legal action within 6 years from the default, so then prescription period, running of prescription period comes to end. So that means that you have taken action, but as you are aware, the legal action can go more than 5 or 6 years. It doesn't matter. You have to initiate the legal action within the period, right? Then the question is whether if we deposited money, whether we can appropriate that money against the money in the account. The answer is without permission of the court. Once you take legal action, you can't appropriate the money against the facility which is before the courts. So therefore, you can't do that once you take legal action. Is that clear?
Yeah. Has bank right to block this account until the litigation is over? I mean, when the customer deposits this money, so
Yes.
Has bank right to block this account until the court, until the case is over?
Hold the money.
Yeah.
You can hold the money unless there's no specific instructions, right? If we deposit money with specific instructions, then you can't hold.
when I mean, if it is the legal action is going on, the litigation process is going on, right?
Yes.
So when the money comes to the account, and
Yes.
the bank has not any right to block this account unless otherwise given the instruction.
Yeah, it's like this. Now, if there is no instruction from the customer, bank can hold.
Right.
Right? If he gives instructions, then the bank has to abide by the instructions. So, clear?
Yes.
Yes.
But unless I mean, if it is the process is going on, the litigation is going on, so
Yes.
we have no right to block the account unless given the instruction.
Unless there is no instructions to no specific instruction from the customer to appropriate the money to a specific purpose.
Right. Okay.
Right? So then if there is no instruction from the customer, the bank has right to hold. But if customer gives instructions to appropriate the money for a specific purpose, for example, customer deposit money and give instructions to bank to pay a check, then you can't hold the money. You have to pay the check. You can't say that you are under litigation, your loan is under litigation, therefore we are holding the money, we are not paying your check. So because then the customer can sue the bank, because he has given instruction, specific instruction, the money deposited to the account for a specific purpose, that is to pay the check. The bank has not observed the instruction and returned the check. So then he can sue the bank in a separate action, because bank has no right to hold that money when there is a specific instructions from the customer. But we say now the customer has deposited money to his savings account, has not given any instruction to the bank. So then in that case, the bank has a right, lien rights. So use that lien right, and we can hold that money until we get permission from courts to set off that money against the loan facility which is under litigation. Clear?
Yes. Thank you.
Right. Any other questions from here? Right. So then we will go to the next one, the combination of account or right to set off. So the singular, the word that we use is ekabadda kirima and hilav kirima. Set off means hilav kirima. Combination of account means ekabadda kirima. Right. Banks' right to combine accounts. Common law rights. When a customer has two different accounts at the same bank branch, the bank enjoys the common law right to combine said accounts without informing the customer. So combination of account, it's a right of a bank. Under the common law, the bank has a right when a customer has two or more accounts at the same bank branch, the bank can enjoy the common law right of combining the said accounts without informing the customer. You don't want to get the permission of the customer, the bank can combine the accounts. Then there is a case law, Grant versus McKeown. The right to combine accounts can be exercised even if the accounts are with the different branches of the same bank. So at the initial stages, it was recognized under the law, under the common law, the bank can combine the accounts of the customer if those accounts are in the same bank, same branch. However, later on, you see, by a case law, it is Grant versus McKeown case, it was decided if a customer maintain different accounts in different branches of the same bank, still the bank can combine those accounts without informing the customer. So we say a customer has a current account at Kolpiti branch of a bank, and he has another current account at Kandy branch, right? So his Kolpiti branch account is overdrawn. His Kandy branch account has a credit balance. So then what is the situation? Can we combine those two accounts and recover the money? So as per the Grant versus McEwen case, yes, the bank has a right to combine the accounts of a one customer, even those accounts are maintained in different branches. That is different from the common right. So does a customer has a right? Any questions from this one? The first combine of accounts.
Yeah, if it is a sole proprietorship account in this scenario, how we should concern?
You mean the individual account and a sole proprietor account?
Yeah, the same customer, individual account, the same customer has another sole proprietor account. I mean, that is the
Yeah,
company
I
account.
understand your question. You say that we say Mr. Silva, he has a personal as a individual account, and also he has a sole proprietor account, which is a business account. Right? You asked whether we can appropriate that or we can combine those two accounts. So good question. For the time being, I'm not answering that question because that is a one principle that we are going to discuss later. Then you will understand whether we can combine those type of accounts. For the time being, I will not address that question. So later on, I will answer to that question because we are going to study that later. Okay. Right. Any other questions or any other concerns? Right. Oh, then I will go to the next one. Does a customer has a right of combination? Now, combine accounts. Now you see this one, right? Bank's right to combine accounts. It is right of a bank, right? Bank has a right to combine the accounts if a customer maintain more than one account in a bank, right? Under the common law, it says same bank, same branch, but later on it was developed by case law. It is even if it is in different branches, the bank can combine. Bank has a right. This is a right of a bank, combination of account. Under the banker's right also we discussed. Now the question is whether the customer also has a right. Now, for example, we say I have two accounts in a bank, right? I have a current account, two current accounts in a bank. Whether I have a right to combine my accounts. That is a question as a customer. Now, bank has a right that we discussed. Now, we take an example. The customer has two accounts. Account A has 10,000 and account B has 2,000. Customer issue check for 5,000 and 6,000 from account A. Now you see account number A has only 10,000 rupees. Now he issued two checks. One is 5,000 and the other one is 6,000. Right? We say in the first account, the bank has to appropriate the money first come first serve basis. We say the customer's first check 5,000 came to the account and there's no problem. We pay the check. Now the balance is 5,000. Then the second check comes. When the second check comes to the account, there's no sufficient funds in the account. So then the question is whether the customer has a right to combine the accounts, right? Whether he has a right. So that means that he has given instructions. Can he say that he gave instructions by exercising his right by combine the accounts and pay? So that means he has combined the accounts, account number A and B, and has issued this check. The answer is customer does not enjoy the right of combination. It is not a right of a customer. It is a right of the bank. So therefore, customer by his own decision can't combine the accounts of his own accounts and issue checks. However, the customer can make a request to the bank. to combine and pay. So bank has a right to do that. Bank has a right to combine accounts. When you say when we have a right to do, so that is a discretion of the bank. When we have a right, we can either exercise our right, so we can just sleep over our rights without doing any without exercising the right. So as a right, the customer cannot demand that from the bank. So no combination for customers benefit if there are no funds available in the accounts. No combination for customer benefit if there are no funds available in the available. So that is the principle. Remember what is the principle? The combination of account is a right of the bank. Initially, under the common banking law, which says if customer has more than one account in the same branch and the same bank has a right to combine. The later on it was improved by another case, and now the situation is bank can combine. Bank has a right to combine. Bank has a right to combine the customer's account without informing the customer if he maintains more accounts in a bank, even in the different branches. Customer does not have a right to combine his account. He has no right. As a right, he can't ask, but as he can request from the bank, bank has a discretion whether they are going to combine the accounts or not. So that is the combination, the right of the banker and the right of the customer with regard to the combination. Any questions?
Hello, sir. Hello.
Yes.
That means even though the customer make a request to combine accounts, still the bank has it should be done at the discretion of the bank, not on, I mean, even though he requests bank, if the bank thinks the bank can reject that request, is it?
Yes. As a bank is not obliged to follow the instruction because bank has a right. It is not a right of the customer. Customer has no right. When there is a right, customer can demand the bank. Customer can give clear instruction, combine and pay. Right? That is a instruction. That is a demand, or that is a order. For example, check is a order to the bank. Right? Likewise, customer in this situation can't give an order to the bank. It is a request of the customer. Customer can make a request to the bank. Bank has a discretion. Bank can either accept the customer's request or bank can reject the request. But as I'm telling you again, when a customer requests for such combination, the bank should not just deny unless there is a reason. Because as a banker, we have to think about the benefit of the customer. But when a customer instruct us to or request us to combine the accounts, we should basically obey unless there is a reason. Now, for example, we say, take the same scenario. Now customer has two accounts. One account he has the money. The other accounts he has overdrawn. The customer request from the bank to combine the accounts. In a situation like that, banker can refuse his request and say that we are not abide by your instruction because we have a reason that we want to recover the money. So this is very tricky situation when you sometimes the court says that banker has to follow the specific instruction with regard to the appropriation of money deposited to the account. At the same time, the bank has a right to combine the accounts. So then the question is, which one supersedes the other? Whether it's appropriation or whether it's a combination. These two are contradicting to each other. the right to set off, right to combine, and appropriation of money. So appropriation of money, the customer has first right, bank has second right. When it comes to combination, bank has a right, customer does not have a right. So these are very tricky situation where we can't say which one supersedes the other one. It depends on the circumstances, depends on the facts of the scenario, and we have to decide which one we have to follow. Whether we are refusing to combine the accounts, whether we have to take the instructions of appropriation of funds. Likewise, it's very complicated situation when you have two principles, law principles, which contradict into each other. So as the answer for your question is, the bank has discretion when they are exercising right to combine. The customer cannot demand that from the bank, so therefore the bank can ignore the instruction or the request of the customer, and bank can avoid the combination if they wish. That is the answer for that question. Is that clear?
Yes, thanks.
Any other questions from here? If not, I will go to the next one. So the limitation on combination. The second limitation, there is implied agreement to keep accounts separate. The bank has to right to force debit the current account. The bank has no right to force debit the current account. So this is another thing, another situation, another limitation with regard to the combination. So what is the limitation? There is an implied agreement to keep accounts separate. So there is an implied agreement between the banker and the customer to keep the accounts of the customer separate. So that is agreement. Implied means not written agreement. It is understanding. It is agreement by conduct to keep the accounts separate. Then bank has no right to force debit the current account. So bank cannot force debit the current account and recover the money. So that is another principle. So that is another limitation with regard to the combination. Bradford Bank versus Cliff, I don't know how to pronounce this. 1918 decided case. If there is a debit balance in the loan account and credit balance in the current account, the bank has no right to combine because of an implied agreement to keep accounts separate. So you see another case decided in 1980. When you see the order or the judgment given here, that is, you see now it is contradictory to the right to set off and combination. It says if there is a debit balance in the loan account, and that means the loan account has been defaulted, and the credit balance in the current account, the bank has no right to combine because of an implied agreement to keep those two accounts separate. So there is an implied agreement to keep these two accounts. So therefore, the court said the bank has no right to combine and set off the money. On the other hand, it says the bank has a right to set off, and you can set off the money against the dues dues to the bank. So these are, as I told you before, contradicting judgment or contradicting law principles, where you can or where you have to practice very I would say very cautiously, with giving all consideration to the principle. Just don't practice these principles of the principle of combination, set off, lien, right? Though those rights are given, Those are very, very limited rights given to the bank. When you are exercising these rights, right to combine, right to set off, uh, right to appropriate, those things that you have to very carefully use when you are exercising. So that is the second limitation on the combination. Right. So then the next one, in a situation of insolvency or winding up, what is the situation? National Westminster Bank versus Holsworth. The bank agreed not to combine two accounts of the customer within following 4 months. In the absence of material change circumstances. So what happened with the company? The bank had an agreement. What was the agreement? Bank agreed to this account has more than one account. So this company had more than one account. So the bank agreed to not to combine two accounts for 4 months. So there is an agreement between the customer and the bank. In the absence of material change of circumstances, the bank said that we will not combine your accounts for 4 months unless there is a material change of circumstances. So they agreed this on April 1968. So then what happened? In June, the winding up order of the company was made. So then what happened? The company in June, April they enter into this agreement. In June, the company went for winding up. Now you see there is a material change of circumstances. Then what the bank did, they combined the accounts. Combine the two accounts. Against that, the company went to courts. Then the bank argued that they could set off or combine the accounts, but the liquidator opposed. So what happened? When the winding up order is given, when the liquidator is appointed, the liquidator's duty is to collect all the dues to the company and pay the credit, the debits, pay the loans and everything, and close down the business. So then what happened? Once the liquidation order is given by the courts, immediately bank combined the accounts and set off the money from the accounts of the company. Then the liquidator opposed to that. Liquidator said, no, the bank has no right to do that because bank has agreed to keep those accounts separately for 4 months. Then the banks argued otherwise. It was held that the bank has a right to combine the account because the material change has occurred. So what is the agreement? Agreement say that the bank will not combine those two accounts for another 4 months in the absence of material change of circumstances. So the bank argued the winding up is it's a material change of the company. So therefore, banks is not obliged to keep those two accounts separately. So therefore, the bank has a right to combine. So court held the bank has a right to do that because it is a material change of circumstances. So therefore, the bank can exercise right to combine. So that is insolvency situation, the bank can combine the accounts. The principle to keep the account separately comes to end because it is a material change. So any questions up to now? Any questions? Okay. So if you don't have any questions from these, then I will go to the next one. That is account in different capacities. So previously you asked a question whether a customer maintain two accounts in an individual capacity for personal use and another account, we say proprietorship account for business purpose, whether we can exercise the right of combination. So this is the answer that for that. the accounts in different capacities. This is another limitation with regard to the combination. So that is why I said the combination, even though it is a right given to the bank, it is a right with lot of restrictions, limitations, where basically you can't practically exercise. So even though the right is there, the bank has no right to combine the balance of accounts in two different capacities, though operated by one person. This is very interesting, right? Now one person maintains several accounts in a bank. The bank has the right to combine. However, it is limited. What is the limitation? If this customer maintains accounts in different capacities, those accounts cannot be combined. Now, for example, I have given here attorney at law, lawyer operate two separate accounts in the same bank, right? He has two accounts, account A and account B. Account A is his personal account. So account A, the lawyer's personal account, that carries his fees and charges that he charged from the clients. So his personal money. The second account, B, is where the deposit and draws out monies of his clients. Now those two accounts, second account, the money that the account he maintains for the purpose of keeping the money of the clients. Now you see, the lawyers, they get money from the clients to pay stamp duty, taxes. Likewise, for a various purpose, the clients give money to the lawyer. The lawyer then pay the relevant authorities on behalf of the customer or their client. So those money also they keep in an account. Now, when you looked at these two accounts, you can't see a difference. Both are in the same name, same person's name, right? So we can't recognize a difference. So both, it look like two personal individual accounts of the same person. However, when you see the purpose of the account, maintaining these two accounts, purpose of maintaining the accounts, one account he maintains for his personal use, personal money. The other account he maintains for the purpose of drawing the monies of his clients. So if you combine these two accounts, what will happen? So we say his personal account is now overdrawn. So other account, there is a credit balance. So then if bank exercise the right to combine and set off the money in the B account against A account, what will happen? So the client's money in the B's account will be utilized or will be appropriate against the dues of the lawyer in personal capacity. So that then is wrong. So therefore, the principle is the bank has no right to combine the accounts of two different accounts if those accounts were maintained in different capacities, even though it is operated by the same person, the same name. So that is the principle. So remember, so the question that you asked, whether a person is maintaining two accounts in individual name and the other one for the purpose of business, now it is coming under this. Two accounts operated by the same person, however, in two different capacities. So therefore, the bank has no right to combine those two accounts. So that is the answer for that case, that question that you asked. Is that clear? Any questions from here? Any questions? So then I have a question if you don't have. So then if accounts are maintained by one person, operated by one person, and accounts are maintained under the same person's name, how do you recognize whether those accounts are maintained in different capacities? Now, we say Nimal Pereira, he's maintaining more than one accounts. All accounts are maintained under his name, Nimal Pereira's name, right? We say he has a savings account and a current account. Now, his current account is overdrawn, his savings account has money in the other account, savings account. You want to combine and set off. Now you know there is a restriction. You can't combine those two accounts if those accounts are maintained in different capacities. The question is, how do you understand, how do you recognize under what capacity those two accounts are maintained? Are those accounts are maintained in different capacities or same capacity? If it is same capacity like personal capacity, of course, then you can combine the accounts. Otherwise, you can't because there is a limitation. Rangana, can you answer to that? How do you recognize the purpose or the capacity of the accounts? Can someone answer to that question? Rangana, are you there?
Yes.
Yeah. How do you?
Unless he has declared the purposes of these accounts, in practical scenario, banks will not be able to.
Yeah. Okay. Yeah. Yes, you are there, right? Yeah, your answer is somewhere they are not complete. Now, you said that unless he declare, at what time that he declare the purpose?
At the opening of accounts, I think.
Exactly. That is the answer, right? You know, at the time of opening the account, we gather information from the customer, right? And one of the information that you have to get from the customer, for what purpose, in what capacity that he is maintaining the account. So if he has declared that he is using this account for his personal use, or if he has declared both accounts for the purpose of personal use, that means that he maintained those two accounts in his personal capacity, same capacity. If he has declared one account for his personal use, the other one is his professional or business purpose, that means he is maintaining two accounts in two different capacities. So therefore, the bank has no right to combine those two accounts. So it is at the time of opening the account, the bank has to get that information from the customer. The case decided is Davidson versus Barclays Bank Limited, 1940. So it was decided in this case also, if one customer maintain more than one accounts in the same bank in different capacities, so then the bank has no right to combine those accounts. Then there's another case that I want to discuss with you, that is Bogle versus National Punjab Bank. It is an Indian case decided in 1988. The bank had held two accounts, one account in the name of X and other was in the name of Y. Now here what happened, there are two accounts. One account is in the name of X, the other was in the name of Y. Bank believed that both accounts were nominee accounts operated on behalf of a third person, Z. So the bank, now there are two accounts maintained by basically two people, X and Y, but bank thought that these two accounts are maintained for the purpose of a nominee for a third party Z. So the bank thought the Z is maintaining these two accounts for his behalf in different names. So then what the bank did, the bank combined two accounts and set off the OD and refused to honor the checks issued by X. So what happened? So there was a OD balance in the Z account. So what the bank did, bank thought this X and Y accounts are maintained by Z in different names. So therefore they combined the accounts and set off the OD balance. Now when the checks comes to X account, there's no sufficient funds in his account now because of the combination and set off, and his check got returned. So then he filed action against the bank. It was held that the bank has no right to combine two separate accounts because those accounts are not maintained by the same person in the same capacity, and bank has no right to assume that those the accounts are maintained by the same person or same capacity unless there is a clear evidence for that. So therefore, it is very important for us also, even though we have right to combine the accounts, it is subject to a lot of limitations. So therefore, we have to be very careful and we have to be satisfied before we combine the accounts and set off. We have to see whether the accounts are maintained by the same person in the same capacity. That we have to be very sure before you exercise right to combine. So any questions from here?
Yes. Say in a scenario where a person has a sole account and a joint account with another party, does it comes under this capacity section?
No, definitely not. You see, once you say one is a individual account and the other one is a joint account, it is not the same person, and also it is not in the same capacity. So one is a joint account, the other one is a individual account. So there are two types of accounts. It's not in the same capacity, and the money in the account of the joint account is jointly owned. So there is a principle called survivorship. So one is dead, the other one gets the whole money. So therefore, it is not in the same capacity, no right to combine those two accounts. Clear?
Yes, thank you.
Right. Any other questions? So we'll take a scenario like this. We say customer maintains a current account and he has opened a minor account for his son. He is the guardian, right? So can we combine those two accounts? Right? Customer has a current account. There is a overdraft balance in his account, and he opens a minor account for his son, who is a minor. The guardian is the father who the customer. So can we combine those two accounts?
No.
No, can't, because one thing, it is not the same person, and the other thing is it is not the same capacity. So therefore, cannot combine those two accounts. So that is the answer for that. So joint accounts, husband and this is about the joint accounts. Husband maintains a debt balance in his personal account. His joint account with the wife is in credit. Can the bank combine? So answer is not clear. The can combine if all the monies in the joint account is owned by the husband. So if the bank can combine if all monies in the joint account is owned by the husband. Now, how do you decide that? That is a factual thing. Now, for example, we say husband and wife maintain the account. Husband only doing a job. Wife is unemployed. The money that comes to this account is the salary account, right? In a situation like that, it is very clear that the money comes to the account all owned by the husband. In a situation like that, if husband has another account where overdrawn, which has overdrawn, in a situation like that, you can combine the husband's current account and the joint account and take the money. There's no clear answer for that. There's no clear legal answer for that, unless that you can show the money is owed to the husband. You can't join the account. So basically, what we have to say, if it is a joint account, right, we basically cannot exercise the right to combine unless that you can prove the money in that account is solely owned by the person that you combine the other account. So that is number one. Number two, Abe National PLC versus McCann. In that case, if this discrete, that separate part, for is owned by the husband, and the presumption is that the bank can set off. So if you can show that is a separate part of the combined account is owned by one party, the other portion is owned by the other party, in a situation like that, you can set off, otherwise no. So for example, we say there is a joint account, husband and wife or two parties are jointly owned, and there is a clear indication the 50% of the money is owned by one person, the other person is owned, other 50% owned by the other person, husband and wife. So in a situation like that, you can set off 50% of the account balance against the overdraft of a account in another of that person, husband. So you can't touch other 50%. But general principle is, when it is in a joint account, it is not 50%, 50%. Each person is owned 100% of the money. So basically, unless there is a separate agreement or indication that 50% or whatever the portion is owned by one person and other person owns the other portion. So these are the two principles when it comes to joint accounts. The basic principle is, if it is a joint account, you cannot combine. If there are in certain situations you can. What are those? That is, if you can show the money belongs to one person 100%, then you can join, you can set off that money or combine that money 100% against dues of that person. The second scenario, if you can show that the portion of the money in the account, current account, joint account, is owned by one person, the other portion is owned by other person, then that you can set off or you can combine the particular portion of that particular person against the dues of another account of that particular person. So that those are the two scenarios that you can combine joint accounts. Otherwise, the bank has no right to combine joint accounts, because joint accounts and individual accounts are maintained in two different capacities. Is that clear? That you asked about the joint accounts. Any questions from here? Okay, if you don't have any questions, so that is the end of the first session, that appropriation. Any questions from here? All clear? Right. Okay, then in that case, we are going to discuss bankers lien. We'll have a short break. Now it's 10:25. We'll meet in 15 minutes. We'll start from there. Sorry about that. Yes, banker's lien, as I told you, that the concept that we have to understand uh, very correctly, we should understand the legal principle behind this, and we'll see. Then thereafter we can use this word in more correct way. So, what is banker's lien? Now, I will explain this banker's lien with an illustration. So then it will be easy to understand. You see, now we take this illustration. Mr. Silva is a customer of X Bank. He had deposited some share certificates owned by him as an additional security for a loan which he later pays. Right, so Mr. Silva, he has taken a loan from the bank by keeping his share certificates as a deposit, or as a security collateral. So then he paid the loan. Mr. Silva forgets to take back the share certificates. About 2 months later, he takes another loan. Now what happened? He settled the first loan, but he forgot to take the share certificate back. So the share certificates are in the possession of the bank. This is very important, the words that I use. The security or the document or the goods are in the custody or in the possession, rather not the custody, the correct word is in the possession of the bank. Now he takes another loan. About 2 months later, he takes another loan, but on this occasion, he does not give security on the loan. So the second loan is a clean loan without any collateral. The previous share certificates were given for the previous loan, and those security or the collateral or the share certificates now have not been given for the second as a security for the second loan. Mr. Silva defaulted the second loan. Now, second loan he defaulted. Bank is entitled to hold the share certificate by exercising the lien rights. Now, remember, even though the share certificates are not kept as a collateral for the second loan, which is a clean facility, the bank can exercise the lien right and hold the share certificates until the second loan is paid by the customer. So that is the principle behind this, right? That is a lien right that the bank can exercise, hold the property or hold the share certificates until the second loan or the second loan settled by the customer. What is the basis of this principle? It is an implied right of a bank derived from the banker-customer relationship. The banker's lien right is an implied right, not written in the agreement or anywhere, but it is a accepted principle of law and accepted right of the bank under the banker-customer relationship. So you see now the banker-customer relationship applies everywhere. So that's why I said the banker-customer relationship is very important, and unless and otherwise you understand the banker-customer relationship properly, that you will not understand the law principles derived from the banker-customer relationship. So this is one of the right of the bank derived from the banker-customer relationship. It is binding upon the bank's customer whether they know for it or not. So the customer cannot say that we are unaware of the lien right, so we have not given the property or the shares certificate or whatever as a collateral, and we have not kept that as a lien. So that is not a defense to the customer. Without the knowledge of the customer, whether they know or not, whether they know it or not, the bank has a right to exercise that right. So the bank does not want to inform the customer that you are keeping this property or the goods in your possession as a lien. So, however, if customer requests to release the security which is in your hand, in your possession, then you can inform the customer, unless and otherwise you settle the loan, that we are not releasing the security. That is the right. That is the right that you get under the banker's lien. The moment the person becomes a customer of the bank, this lien rights starts, right? When this arise, as you know, when the customer when a person open an account with the bank, immediately the person becomes a customer of the bank. The banker-customer relationship start from there. So the moment the person become a customer, the lien rights bank gets the lien right. The customer need not expressly agree to be subject to lien. That is the other thing that we have to remember. Customer need not to expressly agree to subject to the lien. So even though he has not agreed, even though he doesn't know anything about the lien right, it is a right of the bank which start at the point of opening the account. That means, in other words, at the time of banker-customer relationship starts. Any questions up to now? Or shall I discuss these slides and then we'll go to the questions? Okay. Specific features of the banker's lien. The banker's right to retain the possession of the assets of the customer. Banker's lien is exceptional. It carries with the value rights of sale and accupment. That means that you can recover by selling the securities. It is an implied pledge. In other words, it's an implied pledge, so that the bank can sell the security without recourse to courts. So before I discuss this part, I would like to ask you if you have any questions from the introduction part of lien. You can raise if you have any questions.
So
Yes.
Can you once again explain this illustration? I mean, does that mean after a previous security of a facility can be utilized for another defaulted loan? I didn't get that.
Okay, right. I understand your question, right? Now take the illustration. You have to very carefully study, or you have to very carefully see, right? In this illustration, I have never mentioned that the first loan settled by Mr. Silva and he requests to release the share certificates, right? And bank can held or hold the share certificates when he requests. It is not the case, right? Now, for example, we say, forget about the second loan. We will talk about the first loan, right? Mr. Silva, he took a loan. He applied for a loan and he kept his share certificates as a collateral to the loan. Now, we say he paid the loan. After repaying the loan, the Mr. Silva is entitled to get his security back, collateral back. So he can ask the bank to release the security. If he requests to release the security, then the bank has no right to keep those security further, because the facility secured by the collateral is settled. So security is given for the purpose, and the purpose is accomplished. The bank has to release the collateral. Now, what has happened here? It's a unusual thing. This kind of thing could happen very rarely. Mr. Silva, even though he has settled the previous loan, he forgot to take the certificate back. Right? So you see, now the bank cannot by force keep the share certificate after settling the loan. So the certificates are in the possession of the bank. The customer has voluntarily handed over the collateral to the bank's possession, and he forget to take the security back after settling the loan, first loan. While the certificates are in the possession of the bank, customer take another loan, and this time it is a clean loan, right? And it is default. In a situation like that, the previous collateral that you hold with the bank, you can keep until the customer settle total dues to the bank. That is called lien, right? So in other words, if customer has more than if customer has taken a security facilities and keeping securities in the bank, and if he settle one security and if he has not request to release the security, so then you can keep that security as a lien until he settle the other security, even though that facility is a clean facility. However, two things that you have to remember: you can't by force take the possession of the goods and say we are keeping that as a lien. That is not accepted. So that is not lien. The other thing is, if a particular security or collateral is given for a particular purpose, and if the purpose is accomplished, then it is the duty of the bank to release that, right? If customer asks to release, then you can't by force keep those collateral saying that you have a lien, so therefore you are not releasing. So that is another thing that you have to remember. So as I told you, this is a lien. The lien is a right given to the bank, but as combination or set off or appropriation, the lien rights also can be exercised by the bank in very limited circumstances only. So that is the answer to that. Is that clear?
Yes, sir.
Yeah. In that what I want to say you is don't think that we can hold the collaterals of another facility after settling the facility by force, saying that we have a lien right, so therefore we are not releasing the securities until you settle the other facilities also. It is not so. If it is given for a specific agreement or a specific purpose, if that purpose is accomplished, then we are obliged to release the securities. The lien can be exercised in this scenario. You see this you see it's not practically, normally it's practically won't happen. Very rarely this type of thing can happen. So that's why we say the lien rights are, even though it is there, it is not practically possible to exercise, because this kind of scenario won't happen very regularly. So that it's about the illustration. Any questions from
The simple the example just I want to ask, when the customer is enjoying the leasing facility, we will so that we keep the registration certificate as a security and kept the lien. And in the meantime, customer is applying for another facility, let's say about housing loan, right?
Yes.
So the leasing facility is almost finished. I mean, that is totally settled. But at the time, the housing loan is get arrears. I mean, that is sometimes might be defaulted. So if there any possibility to keep this the vehicle registration certificate at that time,
right?
at
So
that position.
okay. So your question, whether under banker's lien, whether we can keep this vehicle or the registration book.
Yes, yes.
Okay.
Understand this, yeah.
Right. I will advise like this, right? Under the banker's lien, I advise not to use the word lien, right? But you take these two facilities, lease agreement and the loan agreement. If you go through your lease agreement carefully, you can see, I don't know whether your agreements also carried the same, but generally, when I go through the lease agreements used by the banks and the financial institutions or the leasing companies, there is a clause in the lease agreement to say even the lessee settled the total lease rentals, the lessor, that is the company or the bank, has a right to retain the vehicle and the books without releasing the same to the lessee unless and until he settle total dues to the banks on other facilities. So there is a clause like that. So normally what we advise, we don't use the word lien when we are advising to keep the when we are holding the property, the vehicle or the books. So we quote that clause in the lease agreement and we say under the lease agreement we are entitled, you have agreed and we are entitled to hold the books until you settle the total dues to the bank, credit card, loans, and other things, that we say that unless you settle all these things, that we are not releasing the vehicle. That is, if that clause is in the agreement. If it is not in the agreement, under the lien, we have no right to do that because lease is governed under the Finance Lease Agreement, Finance Lease Act, and the lease, it's very clearly says it's given for a particular reason and the particular purpose, and the purpose is accomplished when we have to release the security. And the other thing that we have to that I want to tell you, since you asked this question, under the Finance Lease Agreement, Lease Act, when you enter into a lease agreement, the customer has no right to claim the vehicle at the end of the lease period. This is another misunderstanding between the customer and the banks and the finance leasing companies. It is different from the hire purchase. If it is a hire purchase, customer, that is the lessee, has a right to purchase. So he, at the end of the payment, if it is a hire purchase, the ownership should be given to him if he pays. But when it comes to lease, it's a different. Lease means that you pay rental, the lessee pay rental for the use of the vehicle for a period. So at the end of the period, lease period, the customer, the lessee, has to hand over the vehicle to the bank. Bank is the owner, or bank or the finance institution or the finance company is the owner of the property, absolute owner. So once it is settled, once the lease, all the lease rental are paid, the bank can still take the vehicle and sell the vehicle to somebody else. So that is possible. But in the practical scenario, because the competition in the market, once the lease rental, all lease rentals are paid, all the banks and the finance leasing companies now give the vehicle or transfer the vehicle to the lessee. So that is a practice, but legally it is not required. Are you clear?
Yes, sir.
Right. Okay. So, so my advice is, you can't use the word lien to hold the collateral once the purpose is accomplished. So you have to return the collateral. However, in this special scenario, only that we can use the word lien and hold the securities of the customer. Any other questions? Okay. If you don't have any other questions, then we'll go to the this one. This is another important legal rights attached to lien rights. So very interesting. What is that? That is, the banker has a right to retain the possession of the asset of the customer, and the banker's lien is exceptional. The lien right is exceptional. It is like a pledge. Pledge means that you are giving a facility, a loan to a customer by pledging the goods. The goods are pledged to the bank. So, sorry, if the facility is defaulted, then the bank has a right to sell the goods. For example, we say we give an import loan facility to a customer to import, we say, sugar. So he imports sugar and he pledged the sugar stock to the bank, and he take the loan. So once the sugar stock comes to the warehouse, the bank and the customer will have a dual control, and time to time bank can release the goods, and the customer can sell the goods and settle the loan. If customer default, what we do, we have the right under the law to sell the goods without going to courts, without going through a litigation process. We can take the possession of the goods. The possession is with us because it's a dual control. We can take the possession, and we can sell the goods and recover the loan. That is a unique feature of a pledge. But when you compare a pledge with a mortgage, you can't sell the mortgage property without going to courts unless you have parate rights. So if it is a mortgage that you have to go to courts, you have to get a court order, then you have to sell the mortgage property and recover the loan. Pledge is different. Pledge, you don't want to go to courts. That is a right that you have, that you can sell the pledged property without recourse to courts. So lien also same. The lien is exceptional once you hold the assets. Under the lien, the bank has a right to sell. It carries the valuable right to sell and recoupment. That means recovery can be done by selling the security or the collateral without recourse in courts. So that is very important right that we can exercise under the lien rights without going to courts, that we can sell and recover our dues. For example, we say we have gold articles in our possession. The customer has taken the loan, he has settled the loan, but he forgot to take the gold articles back. He has not demanded, he has not requested. We are keeping the gold articles not for the safe custody, but we took as a collateral, our possession. It is in our possession. So the customer now has defaulted his credit card. In a situation like that, we can inform the customer that we are holding your gold articles under lien, and if you don't pay, that we sell the gold articles. We can sell the gold articles without going to courts, without getting a court order, because it is a right attached to the lien rights. So under that, we can sell and recover the dues to the bank. So this is this is decided and accepted. This right is accepted in this case. Rosenbura versus International Banking Corporation, 1923, decided case, 14 Lloyd's Law Reports, 344 page. It was decided there. So what I want to tell you, what you have to understand here is, lien rights are, it's like pledge. You have the right to sell the lien property without going to courts, without getting any court order. That is another important feature of the lien rights. Any questions from here?
Should bank inform to the customer that what they are going to do? I mean, against the lien, they are dispose the pawning articles in order to meet the credit card's payment.
Yes, it's like this. It's in a normal scenario, what we do before we sell or before we file legal action, we demand money from the customer. So same procedure we follow. We demand the customer from customer the dues, and we inform the customer, if you don't pay within 14 days from the letter date, we will take action to sell the lien property. So that we have to demand from the customer. If customer settle within 14 days, then we don't want to sell, and we can't sell the pledge or lien property. So that we have to basically demand and inform the customer without going for a sale. Is that clear?
Yes, sir. Yeah, thank you.
Yeah, because always remember that under the law, we get the right to sell, or we get the right to file action, or we get the right to go for parate once we demand and customer won't accept or honor our demand. That then only we get a cause of action against the customer. If we demand and if customer pays, then we don't have any action, cause of action against the customer. So that you have to remember. The demand is very important. Demand is the point that we create a cause of action against the customer. So it is needed. So we have to inform the customer, not actually inform. We have to demand from the customer. If it is not honored, then we can sell the lien property. Any other questions? Okay, then I'll go to the next one. Bankers' lien and right to set off. National Westminster Bank versus Holzman Presswork 1972 decided case. The word lien is different, is inappropriate to describe as a banker's right to set off or combine of accounts. This is another important thing that you have to remember. Right to set off, combination of account, appropriation, and lien are not same. Those are 3 or 4 different law principles. So each of these principles, they have unique features. Now, for example, right to set off is another right that we get under the banker-customer relationship, but it is different from the right to lien. And appropriation and also combination of account are also another 2 different principles that we can exercise, or that we can that derive from the banker-customer relationship, which is not actually the lien. So lien is a totally different thing. Lien, in the absence of agreement to contrary, the banker has a lien on all securities in his hand for the general balance owing to him on all accounts. This is the definition that we can give for the lien. Lien in the absence of an agreement to contrary. This is very important that I have underlined the same. The banker has a lien on all securities in his hand for the general balance owing to him on all accounts. In other words, in simple words, the banker can hold the securities until the customer settle everything to the bank, unless there is a contrary agreement. So unfortunately, most of the time there is a contrary agreement. Now, for example, we say the customer take a loan, right? Customer take a loan, and customer, as you know, that when we are giving a loan to a customer, we issue a offer letter, right? Then the offer letter will be signed by the customer, that is offer and acceptance. Then thereafter, customer sign the loan agreements and the collaterals. Likewise, then thereafter, only the loan will be disbursed rather. Right? So then one of the condition of the agreement is customer has to settle the loan as agreed, and the bank has to release the security once the loan is settled. So there is an agreement between the bank and the customer. So customer has to pay, bank has to release the security after settling the facility. So that is an agreement to contrary. So therefore, the bank has no right to exercise lien once the loan is settled. But when there is no agreement to contrary, for example, loan is settled, bank has not released the security. However, customer has not requested also. He has forgot. Now the possession of the asset or the security is with the bank even after the agreement is over. So there's no agreement now between the bank and the customer. So bank just holding the property of the customer, and he obtained another loan. This time there's no security, but bank then has a lien right over the security until the general balance owing to the bank from him is settled. So anyway, the definition that I can give for the lien is this: in the absence of agreement to the contrary, the bank has a lien on all securities in his hand for the general balance owing to him on the accounts. So you see, there are important words there. In the absence of agreement to contrary, it is important, right? The bank has lien on all securities in his hand. So you see, now you can't go and enforce forcibly. You can't take the possession. The security should be in the bank's possession, right? And you can hold the security until the general balance is settled. So that is called lien. Then lien secures customers' total indebtedness. Lien applies to the general balance owned by the customer. It was decided on a Brandon versus Barnett matter. So when you have a lien, when you exercise lien, when the bank is exercise lien, the bank can hold the asset or the security or the collateral or the asset in the hands of the bank until the customer settle total dues to the bank on each and every facility that he obtained. So that is number one. Number two, it covers all sums presently due and payable to the payable by the customer, whether on loan, overdraft, or credit, other credits. So this is very important. It covers all sums presently due. So you can't, for the future dues, you can't keep the security. So presently due and payable by the customer, whether on loan or overdraft or other credits. So if I elaborate this further, it's like this. Now we say a customer has taken a loan and he has kept a security. We say that it's a mortgage, right? And he has taken another loan, which is, we say, clean, and he's paying both loans, right? And the first loan he paid and fully settled. After paying and settling the first loan, the bank has to release the security now. The bank can't say that we are keeping or we are holding your security because you have another facility obtained, and if it will default in future, that we will execute or we will keep under lien this property until you settle the next loan also. That is not possible. You see, it says all sums presently due and payable are covered under lien. So therefore, for the future defaults, that you can't hold the assets of the customer or the securities of the customer as a lien. Then lien secures all the total indebtedness at any given time. Bank of New South Wales versus Ross. In that matter, it was decided under the lien secures all indebtedness at any given time. So that is another thing that you have to remember. Until and unless all debts are paid by the customer, that you don't want to release the lien, you can keep the security for that purpose. So any questions up to now from here?
If the previous facility is individual facility, the next one is a joint facility. Then how we should keep the previous security? How we should keep that? I mean, is there any possibility to keep for the second facility? But second facility is joint.
Yeah, first one it's an individual facility. Second one is a joint facility. First facility he settled and he forget to take the securities back, and we are keeping the securities in our hand. And meanwhile, he has obtained another facility with we say his wife or somebody, which is a joint facility. Your question is whether the second facility is defaulted, whether we can keep the previous security as a lien until they settle the second facility. So the answer is, if it is a joint and several liability, yes, then we can, right? If it is a joint and several liability, because the person is jointly and severally liable means that he is jointly liable for the entire amount. Then it is a personal liability for the 100% of the dues of the facility. But if it is not so, right? If it is not so, then he is only liable for the 50% of the dues. So then we can keep the security only for the 50%, not for the entire amount. So lien, then we have to release once he settle the liability. The total liability is only 50% at that time. Or otherwise, if it is a joint and several liability, yes, we can hold the lien, hold the security under lien. So is that clear?
Yes, very much clear. Thank you.
Right. Any other questions? Okay. Right. If you don't have any questions, then I will go to the next one. Lien on overdraft account. Bank of New South Wales versus Lloyd reports says when a customer has an overdrawn his account, the bank has a lien on checks deposited by the customer unless there is a contract express or implied to the contrary. This is very interesting point decided in court. So when a customer has an overdrawn account, so customer has overdrawn his account, the bank has a lien on the checks deposited by the customer. So the customer has deposited the checks that he received from third parties to this account. So that means that when the check is honored, the money will come to the account. So then the bank has a lien to hold that checks deposited by the customer unless there is a contract express or implied to the contrary. So the bank can then take the money, realize the checks, and take the money and keep that under lien until he settle the overdrawn account. That is a new development. You see, now it's earlier it says that the bank can hold the property, all the securities, once he settled the loan and forget to take the security back. Now this is the court has expanded the lien, the concept of lien, and go further, says the bank can exercise the lien right for the overdrawn accounts also. So that is another development, but again it is subject to a certain condition, that is unless there is a contract expressly or impliedly to the contrary. This is the point that we trapped always, because you see, all our transactions are based on contracts. Most of them are express contracts, some are implied contracts. So when you have a contract contrary to the lien rights, so you can't exercise lien rights. So therefore, again, this is a right that we have, but again, very carefully we have to use, because it is limited by lot of restrictions. So that is about overdrawn accounts. Then types of property covered by the lien. So what are what types of properties that we can hold under the lien? So that is another question that comes to our mind. So what are the types of properties that we can hold? This is one area that the banks have to be cautious. Court interpreted liens strictly. This is another thing that you have to remember. Not only liens, when it comes to set off, combination, appropriation, and lien, these are rights given to the bank, but when it is disputed, the court will interpret these rights very strictly. Yeah, so therefore, we have to be very cautious when we are exercising these rights. As a general rule, all securities deposited by the customer are subject to lien. So basically, the general rule is, whatever the security deposits by the customer, whether immovable or immovable, whatever the security deposit, securities of or the goods or the properties deposited by the customer with the bank are subject to lien. So that was decided in several cases: Brandon versus Barnett, London Chartered Bank versus Australia, of Australia versus White. These are the cases that I can quote. In these cases, it was decided any property, any security is subject to lien if it is deposited with the bank by the customer. So, any questions there? Okay, so then I will go to the next one. Non-applicability of the lien. This is another area that we have to think, right? What are the instances, or what are the assets that is not subject to lien? Lien will not apply when there is an express agreement or circumstances or course of dealing which shows an implied contract in consistence with the lien. So in other words, when you have a different agreement or a separate agreement, express or implied agreement, contrary to the lien, then you can't exercise lien rights. Right? So for example, if you have a loan agreement, and if your loan agreement says that after settling the loan, the bank has to release the security, so you can't exercise the lien right and say that you will not release the security unless you settle all dues, because there is a contrary agreement. So that is number one, right? Then number two, no lien attached where the securities are lodged for an express or specific purpose. This is another area, another point that we trapped, right? All the time when the security is lodged with the bank, it is expressly for a specific purpose. Now, for example, if customer take a loan for housing loan, and if he mortgaged his property for the purpose to obtain a housing loan, that is a security attached or security given for a specific purpose of housing loan. If we settle the housing loan, then you have to release the security, that is a mortgage. You can't say that you have obtained a business loan, and unless you settle the business loan also, that we are keeping your house mortgage under lien. It is not possible, because you have a contrary we have the purpose. The security is given for a specific purpose that was decided in Lucas versus Dorain in 1870 case that was decided. So you see now when you are looking at these decisions made by the courts, you see that court has very strictly interpreted the word lien. It is not, when you go through this judgment, you see it is not actually possible to exercise lien rights, because it has been narrowed down by a lot of judgments and lot of law principles where it keep very narrow room that the bank can exercise lien rights. So any questions up to now from here? Okay, then I'll go to the next one, non-applicability. Also, the lien will not attach to the securities, whether negotiable or not, or to articles which comes to the bank's hand for the safe custody. This is another important thing that you have to remember. For the if customer has given any goods or any assets for the safe custody of the bank cannot exercise lien rights on those assets or goods. Now, for example, you know that the banks provide service, safety locker services, right? Customers bring their valuables and customer keep those valuables in the safety lockers. So the bank is the goods or the assets comes to the bank's hand for the safe custody purpose. So you are the custodian of those items. The bank is the custodian. So therefore, the bank has no right to exercise lien rights over those the items that kept with the bank as safe custody purpose. So therefore, that is limited. So it was decided in Hamilton versus Bank of New South Wales, Dale versus the first case, then the Dale versus Bank of New South Wales. In both cases, it was decided the bank has no right to exercise lien rights over the properties under safe custody. So that is another limitation or non-applicability of the lien rights. Then collection of collections inconsistent with the lien. Collection is a part of the ordinary business of banking, and banker has a lien over the documents that have come into the hands of that purpose. This is another interesting case where the bank collect documents or collect checks on behalf of the customer. So the customer's documents that came into the hands of the bank can kept as a lien until he settle the dues to the bank. This is interesting. Now, for example, we say the customer has obtained facilities from the bank and he has not settled, and he engaged in business of import and export, and some documents, the shipping documents has come into your hands. Now the documents are in your hands, and unless you release the documents to the customer will not be able to show those documents to the customs and get released the items that he has imported. So however, since the customer has not settled the dues to the bank has a right to hold those documents under lien until he settle the dues to the bank. That is possible under the lien right. So you can demand the customer and say that we are not releasing your shipping documents unless you settle the dues to the bank. That is possible. So any questions from here? Any questions up to now? No questions. Okay, so then I will go to the next one. Then no lien on money and credited balance in the customer's account. This is another important point that we have to remember. The question is whether we can hold the money in the account of the customer under lien. So for this question, I have seen, I have observed, I have heard lot of bankers says yes, we can hold the money in the account of the customer. And not only that, I have seen the bank officers put a hold on the bank the customer's account the balance, and put a narration also under lien, right? So the question is whether the banker can put a lien on the customer's account balance, right? So I have given here in red because it is very important. Money paid to the bank account or credit balance can never be subject to lien. This is very important, right? Basically, in other words, in simple words, customers' money in the account cannot be held under lien. Why? Because such money becomes the property of the bank from the moment it is deposited, and no person can exercise the lien over his own property. So this is a very interesting point. You may remember under the banker-customer relationship, we discuss a case, Joachimson versus Swiss Bank Corporation case. In that matter, it was decided once the money is deposited to the customer's account, it is no more the customer's money. It is the bank's money. The bank can utilize that money, invest that money for any purpose, and earn income. And only condition or only obligation on the bank side is to return the money when the customer demand with interest. So that was the decision of Joachimson versus Swiss Bank Corporation. So now you see, as per that principle, once the money is deposited to the customer's account, you can't say it is customer's money. It becomes the money of the bank. So in that case, the concept lien, you can't exercise against the money in the account because it is your own property. It is not the customer's property. So the principle is that because of such money becomes the property of the bank from the moment it is deposited, and no persons can exercise lien over his own property. So no person can exercise lien over his property. So he can exercise, the banker can exercise the lien right against the property of the customer, not against his own property. So that was decided in Holzman case, and it was decided. So remember the principle behind this, that you have to remember, lien rights cannot be exercised against the money deposited in the account. So that is another limitation that you have to remember. So any questions up to now from here? Okay, we don't have any questions, then I will go to the with that I will finish the lien. So any questions from lien or
So
yes?
in this last lien account matter, so right now we are lending against customers' deposits. Does it comes under this, like say we
Right. Okay. So good question. That the banks give facilities against the fixed deposits, right? And we keep that fixed deposits under lien. The question is, since that is bank's money, whether we can keep that as a lien. Remember, we keep the two things. We give or we grant facilities against the fixed deposits, right? For those, we have a separate agreement, number one. Number two, when we are granting facilities against a fixed deposit, we take the certificate, deposit certificate, and we keep the certificate under lien, right? You take the document, you keep the document under lien. That is another thing. And also in your agreement, loan agreement, if you read carefully, it carries a right to set off clause also. In case of default, the bank has right to set off the fixed deposit against the dues. So basically, because of this uncertainty of the law, the bank documents have changed or have drafted in a manner that we can cover everything. So basically, there is a loan agreement which gives the right to set off, and we keep the fixed deposit certificate under lien. So we have combined the right to set off and right to lien, and therefore we can, in case of default, we can set off the fixed deposit and recover the dues. So we are covered there. So otherwise, it is, as you said, very gray area. When the money is deposited in the fixed deposit, that is the money, then the bank's money. How can you take that as a lien? So basically, we are not keeping the money under lien. We are keeping the certificate under lien, and we get a set off letter or an agreement where we can set off the fixed deposit against the dues. So that's how we have covered that uncertainty of a lien. Clear?
Yes.
Yeah, some most instances that the checks are honored over the savings bank, the balances. I mean, sometimes the overdrawn the current account over the savings account, the balances, keep it as lien. So it is not practice. I mean, there is not the practical way to this practice.
I'm not clear what the question. So you say
sometimes when the check comes, if it is not the sufficient balance in the current account,
yes,
sometimes the check will be honored against over the savings account balance. Keep it as lien.
How do you mark the in the system? You put a lien in the savings account? You hold the money.
Not all money. That's the respective amount.
Yeah. So, for example, if we say the customer's current account does not have money, so he issued 10,000 rupee check, and you pay that check 10,000 rupee check by holding 10,000 in his savings account.
Yeah, by overdrawing the particular current account against over the savings account balance on his savings account.
So basically, you are holding 10,000 in the savings account and overdraw the current account.
Current account, yeah.
But you are not putting a narration in the system under lien. You don't put like that, no?
Yeah, that balance should be blocked until the account is regularized.
Right. Okay. That balance will be blocked, but not under lien.
Yes, that normally we are doing as a practice. Yeah.
Yeah, I know, but what I say is, don't use the word lien. That you can block the money on the request of the customer. You can block the money, savings account amount 10,000. You can block, but you can't use the word lien. Or rather, don't use the word lien, because in a scenario like this, it's very rarely the customer challenge, because most of the time on the request of the customer or for the benefit of the customer, we pay the check by overdrawing the account, holding money in the savings account.
In savings account, yes.
Yes, but
we can't use the word as lien, right? That we can use it as the block the account and overdrawn the account.
Yes, you can block the account, but don't use the word lien.
Right. Okay. Thank you. Right.
Okay. Any other questions? Okay. Right. So then so we have covered two topics today. So the next one we are going to discuss about the checks. The next one, but before that, I have to say that there are some topics like types of account that I will skip at this moment. I will do that after this the topic checks, and most probably next week, not the next week. After that, I will discuss the types of accounts under the banker-customer relationship. So today we are starting a new topic or new lesson, that is checks. Checks, as you are aware, is the most important instrument when it comes to the banking. So the checks is a unique feature which is practiced in the banking industry, not in other businesses. Checks are used. What is a check? So check is a negotiable instrument. Check is a negotiable instrument. That is the simple answer that we can give. Check is a negotiable instrument. Then the question comes to our mind: what is a negotiable instrument? Right? Negotiable instrument is like this. Right? It's a document contemplated by a contract. So negotiable instrument is a document created on a contract. Right? So therefore, to create a negotiable instrument, the parties should have a contract between them, and which gives a warranty of payment of money. It's a document contemplated or created by a contract. That documents give a warranty of payment of money, which specify or describe the payee. In that document, the payee's name is mentioned. Describe the payee, and also which is capable of transfer by valid negotiation. So it's a document. It's contemplated on a contract, created by a contract. It gives a warranty of payment to a specific person, and also it is capable of transferring by valid negotiation. So that type of document is called negotiable instrument. So when you say a check is a negotiable instrument, you can see all these features are in the check. Right? So then I have given some examples here, right? Bill of exchange, promissory note, checks, bank draft, all these are negotiable instrument. So as we are aware, the bills of exchange, the promissory notes, checks, bank draft, all these are governed by the bills of exchange ordinance. That is the ordinance, or that is the act applicable to the checks as well. So for the checks, there is no separate act or any separate law. It is also governed under the bills of exchange ordinance. There are provisions in the bills of exchange ordinance which is applicable for the checks. So then we'll see what is a check. What is a check? Check, the definition given here for the check is a check is a bill of exchange drawn on a banker payable on demand, as per section 73 of the bills of exchange ordinance. The definition given is Check is a bill of exchange drawn on a banker, payable on demand as per section 23 of the Bills of Exchange Ordinance. Now, what is a bill of exchange? In a bill of exchange, there are three parties. Now, the parties are the drawer, drawee, and the payee. Drawer is the person who draw the check. Drawee is the person who has to pay the bill. Payee is the person who get the benefit of the check, or rather the bill. Right? The bill of exchange is a document contemplated on a contract. So there are three parties: drawer, drawee, and the payee. Among them, between the drawer and the drawee and the payee, there is a contract. There is a contract, or there are contracts. So based on the contract, the drawer issue a bill addressed to the drawee. So that drawee will pay the money to the payee. So drawer demand, or drawer gives an order to the drawee to pay certain sum of money to the payee. So that document is called bill of exchange. Now the check is a bill of exchange drawn on a bag. What does it mean? Now in a check, the drawee always is a bank. The drawer of a check is always a current account holder of a bank. So check is an unconditional order in writing, signed by the drawer, drawn on the banker, that is the drawee, to pay certain in money on demand in favor of the specific person, that is the payee, or to his order in favor of the bearer. So this is the definition that we can give for the check under section 73 of the Bills of Exchange Ordinance. A check is a unconditional order. So you see, when you get a check, you can't put conditions on the order or on the check. No conditions. But when you compare the check with the bills of exchange, bill of exchange, in the bill of exchange, it's different. It could be there could be conditions on the bill. Number one. Number two, the check is in writing, so it has to be in writing. Right? There can't be verbal checks. Right? Signed by the drawer. The drawer has to sign. The drawn on a bank. The drawee always is a bank to pay a certain in money, a sum in certain money on demand is another important thing. Check is payable on demand in the sense when it is presented, the bank has to pay. The drawee has to pay. You can't postpone the payment. Right? Then in favor of a specific person, the payee, or his order, or in favor of the bearer. If the payee's name is not mentioned, if it is a cash check, then the bearer can take the money, or take the money or the value of the check. So this is the definition given for the check in the Bills of Exchange Ordinance. You must remember this definition. So it is a must, because you can't write your own definition. As per the section 73 of the Bills of Exchange Ordinance, the legal definition, this is the legal definition. Therefore, you have to remember the definition correctly. So then we'll go to this specimen of the check given. So you can see this is a specimen check given by the Lanka Clear. So main features that you can identify there, in the left hand top corner, the bank's name you can see there is arrow, and there you have to put the bank's name. Now today's you don't have to put the bank's name, because the banks print their own checks, so therefore the name is already printed in the checks. Then second arrow shows the payee. The payee's name that you have to write in this space given there. Then the third one, amount in words. So there is a space in the check that the drawer has to write the value of the check in words. And then thereafter, the currency symbol that is there, you can see it's a rupee symbol is there. It could be a rupee symbol, or if it is a foreign check, then foreign currency check, that particular currency symbol will be mentioned there. Then there is a cage there, that in that cage that we have to write the value of the check in figures. Then in the right hand top corner, the date is mentioned, that you have to fill the date. That date is considered as the date of the check. So date that you have to fill there. You can see the date, month, and the year you have to fill in that particular area. Then on the right hand bottom of the check, there is a space given to sign the signature, or place the signature of the check. That is the drawer signature that we have to place there. Then there is a field in the bottom of the check, which is called MICR field. There you can see there are few numbers printed. The first number is called serial number, which is known as a check number. Very important number to the bank. So therefore, you know that the check is recognized by the check number and the date and value. Those are the three features that that are important for the banks to identify the check: number, date, and the value. Then the second code set of numbers carries the bank code. So by looking at the check, that you can realize or recognize from which banks the check has been issued, where the account is maintained. So that this field is important for the purpose of clearing the check. Then you can see after that there is a branch code. So by looking at the branch code, that we can realize, or we can recognize from which branch the check, the account has been maintained, or which branch the check has been issued. Then the next one is the account number. Account number, the current account number from which the check has been issued. Then there is a TC code, which is not mainly that important to the banks. However, it is important to the clearance purpose. So TC code means transaction code, to understand what type of transaction for what type of transaction the check has been issued, whether it's a transaction, that means the issue from the current account, or whether it's a bank draft. Likewise, this TC code is used to understand the transaction. There are bankers in this. With us today. Can someone please tell me if you have experience? Have you used this TC code for any purposes? Gavin, are you aware of this TC? For what purposes that we are using the TC code?
No, sir, I'm not that much aware of it.
Okay, anyone has any idea why we at what point we using this TC code? Honestly, I also haven't met any incident that we use TC code, but my understanding is it is used to recognize the transaction type. Okay, so then right, this is a specimen signature given by the Lanka Clear. You see now it's the length and the width also mentioned there. It's 7-inch the long, and width is 3.5 inches. However, this is a real image of a real check. You can see the name of the bank is there, the branch here also printed, but in all the checks you can't see this one. The date you can see in here, and the name of the payee is there. The value they have typed here, and in letters, and here in this case in figures, and the customer's name and the account number also printed in this check. And you can see it's a company check. Two directors have signed. Those are the authorized signatories. The company is the drawer of the check. People's Bank is the drawee in the check. N Kodituakku is the payee of the check. These are the three parties: drawer, drawee, and the payee. You can see the drawer always is a current account holder of a bank, drawer. The drawee always is a bank, right? So that is the unique feature of the check. Bill, anyone can be a drawer in a bill of exchange, and also anyone can be a drawee of a bill. But when it comes to a check, drawee always a bank, drawer always a current account holder of a bank. Then you can see the check number is here, 62299. Then bank code is there, branch code is there, the account number is mentioned here, and TC number is mentioned here. So this is a real check image, just to understand the main unique features of a check. Then we'll go to the features of a check one by one. The drawer of a check. A check can be drawn by a current account holder of a bank. That we aware. Only current account holders can draw checks. Checks are permitted to be issued from current accounts. Now, this is another important thing. Checks are unique feature of a banking industry, and it is attached to the current accounts. So you may remember when we discuss banker-customer relationship, even in the Chettinad matter, you may remember the court see what are the unique features of a bank to recognize a person or institution as a bank or not, whether that person is a bank or not. So the court decided in certain cases, if you are maintaining current accounts for your customers, then you are a bank, because the current accounts are the unique feature of a banking industry. So current accounts can be maintained the checks are permitted to be used from current accounts only. So you may remember, if you have experienced this, certain banks, private bank, one time they tried to introduce checks books for the savings account. So that was not permitted. That was not permitted because under the law and the banking practice, it was not recognized. the checks from savings accounts. So therefore, it was not permitted. One time, one bank tried to introduce or change the practice by introducing checkbooks for the savings account. So which was not, as far as I know, which was not allowed by the central bank, and also which has not been accepted, that practice, in court of law. Because of that, so that banks thereafter didn't pursue that practice. They stopped that. So initially they used to they try to issue checkbooks for the savings account. Then the current accounts can be maintained at licensed commercial banks only. So this is another important thing, that we have different types of banks today. We have development banks, we have special banks. In some banks, they are not allowed to carry or maintain current accounts. Though they call banks, they are not maintaining current accounts for their customers. So the current accounts can be maintained at licensed commercial banks only. So therefore, they have to get a license from the central bank to be a license to do a banking, commercial bank, to do banking business, and then only that we can maintain current accounts for the customers. Some banks permitted savings account holder to deposit limited number of checks, or issue limited number of checks. As far as I know today, the issuance of checks from savings banks are not permitted, but deposit, you can do deposits to your savings account. The checks can be deposited to savings account for the purpose of clearance, but issuance is not permitted as far as I know. Anyone has any experience with regard to issuance of checks from savings account? Any banks is doing this practice? Gavin, you are. Yes. Any bank? Do you know any bank that permit issue checks from savings account?
No, I don't think it.
Yeah, yeah. One time I think Sampath Bank tried to do this, but it was stopped. As far as I know, the deposits are permitted. Is that correct?
Yeah, for a savings account, you can deposit a check.
Yeah, if the check is in your name, then you are permitted to deposit.
Yeah, it
yes.
should be written on the account holder's name, but even cash checks, even we accept with verification, the manager can decide and accept, but it is not done as a practice.
Okay, right. Thank you very much. So the deposits are permitted, but issuance are not permitted. So therefore, remember that it is a check is relevant to the current account, and limited deposits are allowed in the savings account. A check must be in writing. This is another important point that we have to remember. As per the Bills of Exchange Ordinance, check must be in writing. Ideally should be written in ink or typewritten. That have to remember one thing, the check has to be written, that that we have printed check forms like this. Now when you see this check, you can see it's a written check, and the areas that they have type written and fill the check. So ideally it has to be written, the check has to be written in ink, or you have to write and fill the blanks. Then what happen if a check is written in pencil? The customer has used a pencil and fill the check. So then what is the situation? Whether a check is valid, whether we can accept. only requirement under the law is it has to be in writing. So the method of writing is not mentioned or is not defined in the in any act or any in the bills of exchange ordinance. So therefore, the question, the practice is we use the ink pen, or we typewrite on the check. So question, when a customer use a pencil, what happen? Whether we can accept? The answer is may be accepted. So if it is not illegal, so therefore it could accept, may be accepted. Then there is a qualification. What is that? But if there is a reason to suspect, the banker should not pay such check without a confirmation from the drawer. That is very important. If a check is written in pencil, check is valid, don't say it is not valid or illegal. It is valid because it is in writing. Then the collection or the payment is subject to a qualification. What is that? If there is a reason to suspect, the banker should not pay such check without confirmation from the drawer. So how do you decide, or how do you think whether there is a suspect or not? So writing a check using a pencil is a reason to suspect. That is my understanding, right? Today you can find a pen. Why you have not written that by using a pen, or why you have used a pencil? As you know that when it is written in pencil, that it is very easy to alter. So anyone can just erase the pencil writing and you can alter, you can write it. But if it is a pen, of course, it is not like that. You can't alter. If it is altered, alteration is visible. So therefore, if the check is written in pencil, if there is a reason to suspect, the banker should get a confirmation from the drawer. That is one thing that you have to remember. Then printed check form. The next question is whether the customer should use the printed check forms, or whether they can just use some paper and write a check. So because as per the definition of the bills of exchange ordinance, which says the check has to be in writing, it doesn't specify specify how to write, or what type of design that you have to use for a check. So then the question is whether the customers are bound to sign or issue checks by using the check forms given by the bank. If a banker refuses to honor a check which is not drawn on printed check form, the banker should give reasonable notice to the customer. So this is very important. If you are not accepting any other format of checks other than the checks, printed checks forms given by the bank, you have to inform that to the customer, and also you have to give reasonable notice to the customer. So have you given reasonable notice? Do you give reasonable notice? Yes, we do give notice. We give notice at the time of opening the accounts. If you go through your account opening papers, current account opening papers, there you have terms and conditions. In those terms and conditions, there is a condition to say the customer, the current account holder, should use printed check forms given by the banks to issue checks. So it further says that bank customer should not, cannot use any other format other than the checks forms given by the bank. So therefore, the adequate notice we give at the time of opening the account. So therefore, customers are bound to issue checks on check forms given by the bank. Or otherwise, the customers can use any form or any format to issue checks. It is because the legal requirement is issue the check in writing. That's it. So therefore, today's context, basically we don't accept any other check forms, and it is not possible to accept any other form of checks, because as we are aware that we have clearing process. Unless the check is given or written in the given format, in this format given by the Lanka Clear, so the clearance part will be difficult. So therefore, so as a practice, no bank will accept any other format other than the format given by the bank, or forms given by printed check forms given by the banks. So the customers now obliged to issue checks on the given check leaf. Then signature of the drawer. The signature of the drawer, a check has to be signed by the drawer personally or by the authorized signatory. Now, if it is an individual account, the account holder has to sign the check. Himself, he has to sign the check. If it is a corporate account, then as we are aware, the corporate entity is not a natural person. It's a legal entity. It doesn't have any life. So therefore, the company or the corporate entity has to authorize officers of the company to sign the check. So that can be the authorized signatories can be appointed by a board resolution by giving authority to an individual or two persons to sign checks on behalf of the company. So those are called authorized signatories. Then a check can be signed in ink or pencil or mechanically or rubber stamps. These are the methods of signing a check. A check can be signed by ink, using ink. So the individual or the corporate, if it is a corporate account, then the authorized signatories can use an ink, pen, and sign. And also, you can use a pencil and sign. As we discussed before, a check can be written in pencil. So therefore, you can use a pencil to sign. And also, mechanically signed checks are there. And rubber stamps also can be used to sign checks. My question, have you seen a mechanically signed checks and rubber stamp signatures in checks? Have you seen these two types of checks?
Yes.
Yeah. Okay. Mechanically signed checks. Have you seen mechanically signed checks? Mechanically signed check means when the check is printed, the signature of the drawer also printed on the check. Have you seen this type of check?
I have not seen. Sorry.
Haven't seen or have seen?
Yes, sir.
I-
Yes. So when was that? So basically, when dividend checks issued by the company, you can see the authorized signatory signature is printed on the check itself. So it is not signed by the CEO or somebody, authorized signatory of the company. You know, the thousands or sometimes thousands of checks are issued to the dividends shareholders as a dividend. So therefore, checks are printed with the check signature of the authorized signatory. At the time of printing the check leaf, the signature also printed on the check. So that is called mechanically signed checks. What about the rubber stamps? Rubber stamps, have you seen the signature cut in the rubber stamp and placed on the signature on the check? Anyone?
Once I have seen.
Have you seen?
Yes,
When was that?
I think on a government, some institution has issued a check once, sometime back.
Okay, right. So generally, if you see, if you come across a situation where you know that the lawyers, they have law firms, and accountants, they have audit firms and accounting firms, right? When they are signing, they maintain accounts under their business name. For example, we say there are law firms, we say Peris and Peris Associates. So their business name is Peris and Peris. They sign the checks as Peris and Peris Associates. So what they do, when they are signing, they have a rubber stamp. In there, their signature is cut on the rubber stamp, and they place the signature or the rubber stamp on the check. So basically, firms, audit firms, law firms, accounting firms, so those firms basically use rubber stamps to sign checks. So those are the occasions that we can see, we can observe the rubber stamp. So basically, what I want to tell you here is, so it is not necessary to sign the check always by using a ink pen, right? That is the common way, signing the check by using a ink pen. Pencil you can use. There can be situations the check is signed mechanically, that is the signature is printed on the check, and also there can be a situation where the signature is cut on a rubber stamp and placed on the check. So all these checks are valid in law, so it is acceptable. But the typewritten signature is not accepted. So this is very interesting. Reason is not clear. However, as per the law, the typewritten signature is not accepted. Now you will think, what is the difference? If you can place the rubber stamp, if you can mechanically sign, why not typewritten signatures? So the typewritten signatures, I think, because of the security purpose, that is not accepted by court of law, because if you allow to typewrite the signature, anyone can typewrite the signature, but there's no control there. But as you see, if you use a ink or pencil, you can tally the signature of the specimen signature available with the specimen signature available with the bank. So mechanically sign means that is under the heavy security supervision of the company only. The checks are printed, so therefore there's very limited space for a forgery. And also rubber stamp, again, signature is the rubber stamp used by the particular association or the business entity. So there you can actually compare the signature of the check with the specimen signature given to the bank. However, if it is typewritten, it's very difficult to compare and to satisfy yourself as a banker whether the signature genuine or forged. So that may be the reason that the typewritten signatures are not allowed. The signature can be a fiction name or even trade name. So that is the other thing that we have to remember. Signature means that I have seen a lot of arguments regarding these signatures, because sometimes some I have seen some are insisting that when we are signing, that we have to sign our name. It is not so. It is not. A signature is a mark only. It's a design or mark that you use to identify yourself or present yourself when you are giving instructions. So, for example, Mr. Sunil Pereira can sign as a Nimal Pereira, right? When his name is Sunil Pereira, but when he's signing, he signed as Nimal Pereira. So no one can argue that Mr. Sunil Pereira can't sign as Nimal Pereira. He has to sign as Sunil Pereira, because the signature is different from the name, and you can't insist or you can't force anybody to sign the name. It can be anything. It can be even a mark, a circle or a cross or whatever, right? If you see signatures that we use, you can see some nice signatures without you can't read anything. It's just some symbols. So signature is like that. Signature is just a mark that you use to recognize your instructions and others to understand that the signature is given by the account holder. It is not necessary to sign the name. That is one thing that we have to remember. The signature can be a fiction name also, right? So fiction name means there is no particular person in that name, under that name, but can we use that name as a signature? For example, that I can give my specimen signature to the bank, sign as Donald Duck, right? So as you are aware, Donald Duck is a cartoon character that used in Disney movies, which is not a actual character. It's a fiction name. Still, I can use that name. Just an example I gave you, right? It is not necessary me to sign my name. I can use a fiction name or even a trade name. So, for example, that a lot of businesses, they use their trade name as their signature, especially when it comes to law firms and accounting and audit firms. They use their trade name or their firm's name as the signature. The Paul Ratnaik Associates, that is a law firm, they sign as Paul Ratnaik Associates. Actually, it's the trade name. So someone in that business sign as Paul Ratnaik Associates. Likewise, I have given another example here. Nimal Pereira Associate, we say it's a audit firm. Their signature is Nimal Pereira Associates. So it is a trade name. It is not a personal name of that particular business. Could be some business name. However, that also can be used as a signature. A company check can be signed by the agent of the company or authorized officers of the company. So if it is a corporate account, a company account, as I told you before, company is not a natural person. So therefore, the company has to appoint somebody as the authorized signatory to sign the checks of the company. So that is about the signature of the company. So any questions up to now with regard to the checks? Do you have any questions up to now? Okay, since you don't have any questions and the time is past now 12:30, so we'll stop at this point and we'll start next week, next Sunday, from this point onwards. Thank you very much for the participation and your questions. I really appreciate your questions, because from the discussions that we can gather a lot of information and knowledge. So I hope that you will participate and ask questions on the next lesson also. Please read the notes available to you, and be prepared for the lesson next week. We'll continue from there. Thank you very much.